Welcome back to Defending the Windy City with attorney David Drwencke. David is the founding partner of DRD Law, where he focuses exclusively on criminal defense throughout Cook County. Known for his courtroom strength and command of Illinois law, David brings clarity to some of the toughest charges people face in Chicago. I'm Leanne Lyon, and today we are talking about what really happens after a domestic violence arrest in Illinois. From protective orders and bond hearings to what it takes to defend these cases effectively. This is episode number 23, Domestic Violence Defense in Illinois, What Really Happens After the Arrest. David, what does happen right after someone is arrested for domestic battery in Chicago?
Sure. Well, again, thanks for having me. The short answer is you will go to jail. You know, if somebody has made that allegation and said that you've abused them, I think it bears mentioning even just right now that when we hear DV and domestic, we always think husband and wife or boyfriend and girlfriend or something like that, but it can be siblings. It can be a parent with a child. Those all fall under domestic violence because what it is it's a battery, some sort of unwanted contact, harmful or offensive or causing an injury, contact to another individual, but then you'll have that familial connection or your roommates or something like that, dating relationship, marriage, or through blood, child and parent. But the first step is if the police believe that this actually occurred, and it doesn't take an awful lot, it can usually just be the allegation is you will be arrested, you'll be taken to the police station, you'll be booked, and then you'll be held until the next court date, because even a misdemeanor domestic battery, the lowest level one we have, a class A misdemeanor, still involves having to go in front of a judge at what we now call first appearance court because we no longer have cash bail. And the state, at least in Cook County, the state's attorney's office will file a petition to detain you, meaning they want you to stay in jail, not just for an overnight or 48 hours. They want you to remain in custody while this case is working itself out. And of course, it becomes my job or any criminal defense attorney's job to say, well, no, Your Honor, they should be out. And here's why, and go through the steps of a pretrial fairness act or a safety act hearing. But that's the first part is you're going to be hauled off the jail, held, and you may stay in jail if that first appearance court doesn't go the way that you want it to go.
Wow, that has to be terrifying.
Oh, it absolutely it is, because it goes from, if it goes as far as somebody just outright making something up, which is unfortunately not unprecedented, to there just being a misunderstanding. There's loud shouting, maybe inappropriate language, whatever it may be, and one side feels threatened just enough or exaggerates just enough that there was contact. That's a domestic battery. That's domestic violence, and somebody's going to go away. And then if they make the wrong allegation or say something, again, not maybe even realizing the severity of what it means. For instance, officers will ask, hey, you indicated that they touched you around your throat or grabbed you by your neck. Did it impede your breathing? And if the person were to say, well, yeah, I struggled to breathe, I was gasping. Well, now no longer is it just a domestic violence. It's now a aggravated domestic violence charge, and it goes violently up the scale of severity from a class A misdemeanor. That's still no joke. Jail time can be associated with that, to a class 2 felony, meaning you're looking at 3 to 7 years in prison if convicted of that charge. So that one allegation or one exaggeration in what happens during a situation or an incident will not only have you getting arrested, but and potentially spending serious time in jail while the case is working itself out. You could be facing prison time out of an exaggeration.
Wow. Well, let's switch a little bit into emergency and plenary orders of protection. How are they different, and who decides which applies?
Sure. Well, it's a procedural thing. And the first part that I think always surprises clients, and that's, I'll start this way with you as I do with clients, is that even though every single bit about it sounds like it's criminal, that the allegation, hey, they beat me up, they're threatening me, they're stalking me, they're harassing me, they're litany of things you could be doing, unwanted contact, outright, they beat me up or something like that. It all sounds criminal. Well, in reality, an order of protection, both emergency and plenary, are civil in nature. And why does that matter? It really goes to the burden of proof that in my day to day practice, criminal cases that we're taking to trial, it's beyond a reasonable doubt. The most difficult standard, the highest burden of proof that we have in our system. Well, in a civil case, at an order of protection hearing, it's merely a preponderance of evidence. Is it more likely than not? Or a lot of times you'll hear it's just that tipping of the scale one direction or another, or to put percentages on it, think of it as 50.1 to 49.9. And if the petitioner can meet that burden, an order of protection or a stalking no contact order will be put in place. Now, the real key difference between an emergency order of protection and then a plenary order of protection is an emergency order is entered typically when the other side or the respondent isn't there. That somebody has gone typically to the courthouse or the domestic violence building, filled out a petition and said, I need an order of protection for here. Let me list the reasons why and the dates these things have occurred. They'll swear to it. So they'll raise their right hand and say, I am telling the truth. These are the things that transpired and why I need an order of protection. They'll go in front of a judge. And then that judge, without hearing a single word from the other side, will either grant or deny that emergency order of protection. If it's denied, and it happens, not as regularly, in my opinion, as it should, the petition still goes on, where the petitioner, his or herself, will then have to serve the other side and say, I filed this petition. You're going to be required to come to court on such and such a date. We're going to work our way through this and have a formal hearing where each side can be heard, and then an order can be entered. In the far more typical example, the emergency order of protection is granted. And the way I'll explain it for clients and for the podcast listeners is the judge is in an unenviable position. Somebody has come before them, claimed usually a litany of things has happened about being physically assaulted and battered and threats against their life, and that they're fearful for themselves. And albeit for this order of protection, Your Honor, I don't feel like I'll have any teeth to this. I want to be able to call the police and tell them I have an order of protection, or inform the other side I have this, so they'll leave me alone and not abuse me. And of course, unless it is just a smoking gun, stupid, they don't meet the burden type of thing, the judges, of course, want to believe them. They've come down to the courthouse and filled the paperwork, and they've sworn to this, saying that they're telling the truth, albeit with no cross-examination, no review from the other side. So the judges are put in a tough position, so they will routinely grant them. Well, orders of protection, and that's the emergency basis. Nobody's argued for the other side, but they have real consequences. If you own a firearm or have a FOID or CCL, that goes away immediately. You were to turn that in, it's suspended. If you happen to live in the same home, classic example of husband and wife, whoever has the order of protection against the other side, that other side gets served, they're kicked out of their own house. They're not permitted to be there. Property can start to be saying, well, you don't have access to this car. You can't see the children, among a number of other things. There are real consequences, and the other side hasn't been heard. That's the emergency portion of it. The saving grace is, even when an emergency order of protection is granted, that other side will be served with it. Not only will they be told, listen, there's an order of protection, you're going to have to leave your house, among other things, but you'll be given a future court date. And you'll eventually get to have a hearing and say, yeah, I'm challenging this. These things did not occur. They didn't occur in the way that the petitioner is saying they did. And then you can be exonerated later on, and that order of protection can be emergency, can be set aside, not granted. You can go back to your own house and take your property back and see your children, or again, the consequences you've been facing. But that takes time, especially in Cook County. This isn't you get served and then we're going to figure this out 48 hours later. It's you're going to get served, and perhaps a couple of months down the line, you can get back into your house. But if the judge grants it long term and says, yeah, this emergency order of protection, I agree, they have met the burden, they have been abused, I'm going to now make this a plenary order of protection. A judge extends it now, and it can go up to 2 years. The judge can choose to make it less, a month, 3 months, 6 months, a year, but they can go up to 2 years. And the petitioner then also has the ability to extend it. That if for some reason they believe they're still at potentially going to be harassed or abused, they go in front of the court and say, yes, you've given this to me for 2 years. I want to extend it for another 2 years so it can keep going on. The 2 years isn't a hard set in stone thing that it just drops at 2 years. It can continue if the petitioner wants to go forward. That's the plenary order. It's after a formal hearing and both sides have had an opportunity to be heard. And the judge puts pen to paper and says, well, now I'm taking the emergency order and making it more official. And then the police, among other entities, attorneys, know that that's after a hearing. This is a real order of protection. Both sides got to argue this out, and the judge agreed with the petitioner.
So you defend in these situations. What kind of evidence do the prosecutors usually present in these cases?
If the order of protection is tied to an outright domestic violence charge, and a lot of times they are, but not always. Sometimes it's just an individual. The boyfriend or girlfriend goes to the courthouse, files their petition. They do it all on their own. There is no state's attorney. They could hire their own counsel or perhaps go to a legal aid clinic. They usually get involved with this. But the type of evidence we're looking at goes to the petition. Well, what are you claiming happened? Like what, when, and how did this occur? Especially if it's separate from a domestic case itself. If it is tied to the domestic case itself is going to control on an awful lot of this. Is that we're going to go through and see if there's a claim of violence and injury. Are there medical records? Are there photographs of injuries? Is there something to confirm this beyond somebody just saying, well, he punched me? It's like, well, is there any evidence of that? Are there any witnesses? Did this happen in public? Were there pod cameras, surveillance cameras? Were there Ring doorbells that are ubiquitous at this point? And then it goes to a typical criminal case. We'll work through that where both the trial for the underlying domestic violence doubles as the hearing for the order of protection. And we go through it, and we'll actually kind of kill two birds with one stone in those circumstances. If it is just an order of protection, well, then again, it's a civil case, technically, even though again, it sounds like it's criminal. And we'll go through some basic discovery where we ask the other side, what do you intend to bring at a hearing? Do you have text messages, photographs, videos, witnesses? Again, what do you have that you're going to rely on in proving your case? Or is it just you testifying, saying these things occurred? And now we have the benefit, being on the respondent side, of seeing that petition. It's like, you said this happened on February 10th and March 3rd. These are the things that happened. You haven't produced anything else. It's largely or exclusively your testimony. We can cross-examine them, and we can bring our own evidence to show you're saying my client is calling you habitually, but we have phone records that you're calling, him or her as well. Or you're saying that this is unwanted contact, but you're texting them back and inviting them over, or there happens to be video on a specific day. And it's like, what you claim to have happened did not happen, and we have demonstrative evidence proving it otherwise. But every case is a little bit different, but that's what we're looking for, is to directly counter what's in the petition, what's being alleged happen on a given date and time.
So it sounds like there often is opportunity to find evidence, but how do you handle credibility problems when the facts come down to just two conflicting stories?
Those are the toughest. And that's where being in a civil court, as opposed to a criminal one, though we can run into that, where there are no witnesses, there are no photographs, there are no medical records, there's nothing else. It's just someone says it happened, and then you have the other side saying, no, it did not. I mean, the classic he said, she said example. And then it comes down to credibility. Just how believable is this person and their story? And what I'll tell clients, again, because I'm on the respondent side or on the defendant side exclusively, is that I almost hope for and wish for exaggerations. That it's tough to hear on the front end where they're like, he punched me 500 times in the face, and then he kicked me and he did this. And you're like, and of course you could see the client like in the chair spinning in place, so angry because like, I didn't do this. None of this is true. Like their head's going to explode. And it's like, just wait. Like, yes, it's tough to hear this, and they're going to keep repeating this fact pattern in front of the judge. And this is why they want to keep you in jail for a criminal case. But it's like, when this gets to trial and now we're beyond a reasonable doubt, and someone says, I got kicked and punched 500 times. It's like, well, I trust you went to the hospital. You called 911 and you sought medical attention. You had lacerations and bruising and scuffs and this and that. Oh, no. Well, you have photos of your injuries then, correct? Oh, no. Or they didn't seek any medical attention at all. It's like, is that a believable story to have been kicked, punched, 100 times and there are no injuries, there's no swelling, there's no bruising, there's no photographs, you didn't seek medical attention. It's like, listen, that exaggeration is our key to victory, as painful and as frustrating as it will be throughout the pendency of the case. Where it matters most, which is the trial, that will come forward. So that's probably one of the best examples of it, is just exaggerations or things that just cannot be corroborated. In a criminal case, beyond a reasonable doubt, we get to live on that higher burden. In a civil case, man, that is tough when it's razor edge. Like I said, 50.1 to 49.9. Both sides can testify credibly, and then the judge at an order of protection hearing, it's always a bench trial. There's no jury at that.
Mhm.
It comes down to that credibility question, and trying to predict the future if both sides testify credibly, very difficult.
Got it. Being a defense attorney, what should a defendant know about following bond conditions or orders of protection while the case is pending? And we're wrapping up here quickly, so just what can we say about?
The best advice, yeah, follow the instructions of the court. If you're served with an order of protection, don't communicate with that person. That's exactly what that means. By no means social media, text, phone calls. Don't use your family and friends to reach out to the person, because that can be a violation. If it's a condition of release, same thing. It is a court order telling you what you are to do or not do. Obey those conditions, because if you violate, you get sent back to jail. If you violate an order of protection, it goes from being a civil matter, which is frustrating among other things, but no risk of jail. But if you violate an order of protection, that is a criminal charge. And if you do it in the wrong way, it goes from a misdemeanor to a felony. Obey the order, because there are real consequences if you don't.
Excellent. And under what circumstances can domestic violence charges actually get dismissed, which I'm sure is what most of your clients are hoping for? And who has that authority to dismiss those?
Ultimately, it's the state. Now, who has a lot of control of that, especially in Cook County? We'll abbreviate CW. Well, who's the CW? Complaining witness or victim. If the complaining witness or victim comes forward and says, listen, I don't want to do this anymore. I don't wish to press charges. I exaggerated. I lied. I whatever. I've forgiven him, what have you. More often than not, the case will be dismissed because the volume of these cases are so high that the state doesn't want to continue with them. However, under the right circumstances or the right fact pattern, or the state has enough evidence, they'll go E-based, E being for evidence-based, meaning you may have forgiven them, Mr. or Miss Complaining Witness, but we as a society have not. The state's attorney's office has chosen to go forward, and we will, because we believe we have the requisite evidence, be it, again, video, medical records, statements to treating physicians or nurses and so forth, that can all be used, even if the complaining witness does not want to testify or go forward.
How do you approach resolving domestic violence cases in Cook County, and what does a realistic outcome usually look like?
The biggest driver when we're negotiating on a domestic violence is the severity, like just how badly was somebody injured? Was this a pushing shoving incident, or was this somebody who maybe was really seriously injured? And if it meets a certain threshold, again, it goes from that simple class A misdemeanor up to more serious felonies. But the starting point is, well, how bad is it? And then what does the client's background look like? If this is their first brush with the criminal justice system, or if this is their first violent offense, we can usually work something out, which involves no jail time. In the perfect world, what's called a deferred prosecution, where my client jumps through some hoops, does an anger management, a domestic violence course, some community service, and so forth. Case dismissed. It's an agreement with the state to jump through some hoops to make the case go away. Otherwise, it's seeking an amendment to the domestic violence to a simple battery charge. It's the same level of offense. They're both class A misdemeanors, but a domestic violence is never expungible or sealable, meaning it will stick with you for the rest of your life. It will be on your background unless the laws change in a significant way. Whereas a simple battery is expungible. That is something you can get off your background. And sometimes, given the facts, that may be the best that we can do, is try to avoid jail time, amend the charge, and know you can clean your background up later.
Good to know. Well, thank you so much for joining us on Defending the Windy City with David Drwencke. Domestic violence cases move fast in Illinois, and early decisions make all the difference. To learn more or connect with David and the team at DRD Law, visit drdlawllc.com. And don't forget to subscribe, leave a review, and share the show with somebody who might need it. Thank you, David.
Thank you.